Good morning, everyone, and welcome to this immigration update session for HR, What's New in 2023. So for those of you who don't know, I'm Elaine McIlory, one of the partners in the employment and immigration team at Brodie's, and with me today is Erin McLafferty, who will also be presenting, who's an associate in the team. And in terms of the agenda for today, if we just move on to the agenda slide. So the session's got a mix of updates for HR. Some of these changes are already in place, and towards the end of the session, we'll also touch on some forthcoming changes in relation to immigration to keep you up to speed with everything that's been going on, because there's always lots of change for immigration. So we're going to cover some changes to the skilled worker route, including some changes to pay rates, and also we'll touch on some reporting in relation to hybrid working arrangements. We'll cover an update that applies in relation to certain offshore workers, and we'll cover what that reporting requires. We'll touch on the new Innovator Founder visa, which opened in mid-April, so fairly recently, and we're covering that in the context of those individuals being able to apply for jobs with other employers. So you might come across people with those types of visas. We'll touch on an expansion to the youth mobility scheme. And then we'll talk about the Electronic Travel Authorisation scheme, which is being rolled out from mid-November, so in a few months' time, and which will impact business travellers coming to the UK. And then a few forthcoming updates. So I'll just hand over to Erin at this point, who'll start off.
Great, thanks Elaine. So as Elaine touched on, there have been quite a few changes to the skilled worker visa route over the last month or so. One of the most significant is that there's been updates to the minimum salary requirements, and those took effect in April. And what that means is that for certificates of sponsorship assigned under the skilled worker route on or after the 12th of April, the following minimum salaries now apply. So the kind of standard minimum salary is now £26,200 per year, which is increased from £25,600. Or the going rate for the job in question, whichever is the higher of the two, is the applicable rate. And this is subject always to a minimum of £10.75 per hour, and that's increased from the previous minimum of £10.10 per hour. It's also worth noting that those who are relying on tradable points, so that includes anyone who's a new entrant, someone doing a job on the shortage occupation list, or someone who has a PhD in a subject relevant to the job, and that includes a STEM subject, are also subject to new minimums. This can be as low as £20,960, and that's an increase from £20,480 per year in some cases, but there is a minimum salary depending on the tradable points you're relying on, so do always double check the guidance. It's also worth noting that the going rates for each job code have been increased. So in addition, there is an annual salary specified of 37.5 hours per week rather than 39 in the rules, and that's been an update. It used to previously give the annual rate based on 39 hours per week. But do always ensure that you're paying at least the hourly minimum rate for the job in question, and that's also specified in the immigration rules with the specific job code you're looking at. Next, we're going to look at changes to reporting hybrid working arrangements. So there was policy guidance that was published on the 13th of April this year, which sets out the compliance obligations for sponsors. An individual's place of work under the skilled worker route has always had to be reported, but previously the guidance did not have any specific information about hybrid working arrangements and what had to be reported in relation to those. There was a specific concession for home working during the early stages of the pandemic to kind of acknowledge that home working came on very suddenly and on a kind of mass scale, but that ended in the kind of early stages of the pandemic. However, the guidance dated the 13th of April introduced specific reporting requirements. I would note that we do understand the Home Office may amend these obligations due to some feedback from employers and also due to a surge in requests on the sponsor management system from employers. But I would note at this stage there's been no formal announcement from the Home Office and the guidance has not been updated yet. So for the moment, sponsors are obliged to comply with the guidance that's in place, and that guidance dated the 13th of April does require sponsors to report through the sponsor management system, or SMS, via a sponsor note. Firstly, where a sponsored worker is or will be working remotely from home on a permanent or full-time basis. So that's someone who's at home with little to no requirement to attend a workplace or office. And secondly, if a sponsored worker has moved or will be moving to a hybrid working pattern. Hybrid working pattern is defined in the guidance, and it's where the worker will work remotely on a regular and planned basis from their home or another address. That can include something like a work hub space, and that's in addition to attending one of your offices or branches as listed on your sponsor license. As mentioned, the guidance was not explicit before these changes in April, and therefore some employers have not reported historic hybrid arrangements. In line with the guidance, we do recommend that these are now reported for completeness, but do note that bulk reporting is not possible, so you do have to report each of these arrangements for each worker under their specific certificate of sponsorship. Changes to hybrid working arrangements should also be reported on an ongoing basis if they're a change to a regular pattern. So for example, if someone goes from working from home 2 days a week to 3 days a week, that should be reported. If it's a one-off kind of change that's occurring because someone needs a bit of flexibility in a particular week, that's not necessarily a change to a regular pattern, so wouldn't necessarily need to be reported. However, I would say watch this space. As I mentioned, these obligations may change, and we do expect that some of the SMS reporting may still be required in some cases, but it's still to be confirmed exactly what UKVI will require. So for example, a purely remote worker might still need to have some reporting undertaken, but hybrid workers might not. So it remains to be seen what will change. But for now, employers should ensure they comply with the relevant guidance that's in place. And that is the guidance I mentioned that requires employers to report hybrid working arrangements in line with what's on the slide there. And finally, from me, I'm just going to quickly talk about sponsor management reporting. There have been changes to procedures in terms of reporting certain information on the sponsor management system in relation to the sponsor itself. That includes where a sponsor wants to replace their key personnel, so that's their authorising officers, key contacts, and level 1 users. Those changes took effect from the 23rd of March this year, and it means that requests submitted on the sponsor management system to replace authorising officer, key contact, or to add a new level 1 user will be fulfilled immediately. It's subject to certain criteria being met. To qualify, the sponsor must have an active and A-rated sponsor licence, and that means that the sponsor has a current licence and is not subject to any sponsorship action plans. And secondly, the postcode for the new member of the key personnel team must match the postcode for the main organisation or head office address given for the sponsor organisation on the licence. There is an exception to that for key contacts and level 1 users, where the postcode of the legal representative's organisation has to match the address of the legal representative organisation as listed on your licence. So that's the only exception. There's also been changes to implement the auto renewal of annual allocations of undefined certificates of sponsorship on the SMS. This means that A-rated sponsors with an active sponsor licence will have their annual allocations of undefined certificates of sponsorship renewed automatically if they're due to expire within 3 months of the date of this announcement, and that was the 23rd of April. This means that sponsors will no longer need to submit an annual request to renew their allocation as standard, which is good news. And overall, these are good news stories for employers. It will allow instant changes to key personnel in many cases. Previously, for anyone on the session today that's been through this process, it could take up to 18 weeks to have that request processed, which is a considerable period of time, unless employers were willing to pay the £200 to prioritise the request where that was available. And if anyone has used that service recently, you will know it's very oversubscribed and sometimes very hard to come by. So that is good news that you don't necessarily need to go through that process as a default. And similarly, having your annual allocation auto-renew is one less thing for sponsors to think about. And if it's ever been forgotten about, which some employers may have had happen to them in the past, it can again take up to 18 weeks to renew that allocation. And in some cases, or unless that £200 priority fee was paid. So it should hopefully save lots of time for employers and also hopefully free up some of those priority processing service places that are in high demand at the moment, as hopefully more and more of this process will become automated for sponsors. So that's it from me on changes under skilled worker route. I'm going to pass over to Elaine.
Thanks, Erin. So I'm going to move on to talk a bit about some changes that some businesses which employ offshore workers need to know about. So on the 21st of March, the Home Office confirmed that the offshore wind workers concession was going to end as planned on the 30th of April with no further extensions. That concession had been in place since 2017 and had been extended many times, and meant that certain offshore workers engaged in the construction and maintenance of offshore wind farm projects didn't need a work visa to come to the UK. So that all ended. And those workers had to leave the UK by the 30th of April 2023 if they had been working in the UK under the terms of that concession. So that all fell away. At the same time, or around about the same time, on the 12th of April, the Home Office announced new reporting obligations. So those now apply to employers sponsoring an offshore worker, and those notification requirements require the employer to notify of the first arrival in UK waters at the beginning of the job, which the person's been sponsored to do. And this now forms part of the policy guidance for skilled worker sponsors. And they also have to notify of those leaving UK waters at the end of the job. You don't need to notify of temporary sort of coming in and out just for holidays, etc. And in terms of the timing of that reporting, it's up there on the slide, but it has to be done no earlier than the date the worker arrives or leaves, and then no later than 10 working days after that arrival or leave date. And at the moment, it can't be done through the SMS. It needs to be done by email to the address that we've put up onto the screen. For those offshore workers that don't have sponsors, there's an obligation for them to report coming in and out separately rather than the sponsor having to do that. And in terms of what we mean by an offshore worker, that's defined for these purposes as someone who arrives directly into UK waters for the purposes of work without coming through UK landmass. So somebody arriving at an airport, etc., that doesn't count as an offshore worker for the purposes of this reporting. And this reporting is presumably to give the Home Office a better idea of who is sort of coming and going into the UK for work purposes, to allow them to keep better track of that. If we just move on to the next slide, then a further change that I said we would talk about at the beginning is the new Innovator Founder visa route. Some of you may have heard of old startup and innovator visas that we used to have in the UK. Those categories are now largely closed to new applicants anyway. Since the sort of 12th of April, there are some transitional arrangements in place for those who were endorsed under those routes prior to that date, but those categories are largely closed and are going to be replaced, or are replaced, by this new Innovator Founder visa route. And this is a new route opened on the 13th of April for those individuals who've got an innovative, viable and scalable business idea that they've generated or significantly contributed to. So the idea is that it's for those sort of business founders themselves to come to the UK to set up a business. Those individuals apply for endorsement of their business plan or business idea from certain approved bodies, which the Home Office have authorised to give out those approvals. And those individuals can generally get a visa for a 3-year period initially, and it can be extended after that. And the reason we're covering it on the session today is that those individuals can work for their own business that they're planning to develop, but they can also carry out additional work for third-party employers. So it may be that you'll have individuals apply for jobs with you, either on a part-time basis or whatever, who have one of these types of visa and who present this as evidence of their right to work. There are restrictions on the work that they can undertake for third parties. So it needs to be at a medium or highly skilled level, and there's information online about which job codes are suitable for these individuals to work in. So they can't work in low skilled jobs, but there aren't minimum salary requirements or restrictions that apply to the work that they can do, and they don't need to be sponsored by the third party employer that they might want to do a part-time job for. They do have to work towards their business plan, etc. So it's unlikely you'll have people apply for jobs who are on a full-time basis, because they will be also working in relation to the business plan that they've been endorsed for. But it's just a look out for those types of visas. You might see them in terms of right to work evidence, and if you do, it's important to check that they are doing work for you which is sort of authorised under the terms and conditions of their visa. If we just move on to the next slide then. A further change I said I would cover is the expansion of the youth mobility route. Some of you might have individuals who work for you who have these sorts of visas. They used to be known as sort of working holiday maker visas. They are low-cost visas and they allow nationals from certain countries to come to the UK to work for a certain period of time. And the sorts of countries that are currently permitted to apply for these visas are Australia, Canada, Monaco, New Zealand, etc. And the other countries are up there on the slide. And from the 29th of June, nationals from New Zealand will be able to apply for this youth mobility visa if they are up to the age of 35. So traditionally, those visas have been for people up to the age of 30 years old. So this is an expansion to the route. And also the length of stay will be increased for those from New Zealand for 3 years rather than the standard 2 years. And it is a useful visa if you're looking to cover certain jobs, etc., and you don't want to sponsor somebody necessarily. So you might see an increased number of people with these sorts of visas. The route also might be subject to further changes because we've seen a number of changes coming about as a result of trade negotiations with certain countries, including a new sort of slightly different form of visa for India, for example, that's similar to the youth mobility route. If we just move on to the next slide then, further change that I wanted to mention is the introduction of the Electronic Travel Authorisation scheme. And you may have seen some communications from the Home Office in relation to this because this scheme is being rolled out later this year. With the first applicants under it coming into the UK with an ETA from about mid-November this year. So we've still got a few months to go until it's going to be introduced, and they're rolling it out country by country. So gradually over the course of next year, additional countries will be kind of added so that it is that gradual rollout. And in terms of what an ETA is, it's a digital permission to travel rather than to enter the UK. So it doesn't guarantee somebody entry to the UK once they've got it, but it is permission to travel. And it's a new requirement, and it's similar to the US ESTA scheme. If you've been to the States, you know that in advance you need to apply online through that permission to travel there. And it asks a number of questions on a mobile app about your suitability to travel to the UK, including information about things like criminal record or any sort of adverse immigration history. And once it's introduced country by country, then those who don't need a visa to come to the UK will need to have one of these ETAs in order to travel. For those individuals that come from certain countries that need a visa to come to the UK, they will continue to apply for a visa rather than an ETA. So, and there's a list of those countries online. They're called visa nationals, and those tend to be sort of considered to be higher risk countries where individuals do need a visa to come to the UK. In terms of who won't need an ETA, if you're British or an Irish national, you won't need that, obviously, to come to the UK. And also, if you've already got a work permit or other form of visa to come to the UK, you won't apply for an ETA. You will just continue to apply for your visa in the usual way. There'll be a 3-month window before your visit to the UK when you can apply for one. The indications from the Home Office is that it will take around 72 hours to get a result back on your online application. It will be important for people to ensure that time is factored in to apply in advance, because if somebody did get a refusal because they have, for example, a criminal record history or something like that, they might then be directed to apply for a visa to come to the UK. So if you do have business travellers that come, for example, from the States to the UK for business trips, who've not been used to having to have any paperwork in advance of coming, they've not needed visas, they've not needed an ETA in advance, it is worth making them aware of this new requirement. They're going to have to do this in advance. Once they get the ETA, it will be in place for a 2-year period, and it will be suitable for multiple trips to the UK, which is good. You don't need to apply for a fresh one every time. And the only reason it would be valid for less than 2 years is if the person's passport expires before then, in which case you need a new one. There will be a small fee to pay. The details of that are yet to be announced. And we're hopeful that the turnaround times, etc., will be quite prompt because there'll be, I guess, the Home Office is going to have to sort of get resources in place in order to deal with all of these new applications that they've not previously had to deal with. But yeah, in terms of tips for employers then, I think it's just making people aware so that they don't show up to the airport ready to board their flight without an ETA in place. And also, if anyone does have any sort of adverse history in terms of being refused entry to the UK or a criminal record history, etc., it's worth maybe taking advice about the timing of all of that and whether it might be worth applying for a visa instead of an ETA in case the person applies last minute and gets refused and their trip is impacted. So if we just move on to the final slide then, we thought we would just touch on a few additional changes that are not yet in force, but which are coming soon, just to make you aware of these. And this is a hodgepodge of different changes we've got coming. But the first of the changes then is that the UK government announced in the spring budget that it wants to simplify the business visit rules, which is good news because lots of people are often quite confused about what you can and can't do as a business visitor. And hopefully that will extend the range of short-term business activities which people are permitted to do as a business visitor. And if you come as a business visitor, you don't need an actual work permit. So we look forward to seeing what that simplification and hopefully expansion of business activities looks like. They're also going to review the rules on permitted paid engagements under the visit rules. And in terms of the timing for those changes, those are likely to be implemented from the autumn of 2023. So it's likely that we'll see detailed guidance published in terms of what those changes are. Second change that we thought we'd mention is that the Migration Advisory Committee, which advises the government on immigration policy changes, has been undertaking a review of the shortage occupation list. That's a sort of list of jobs which are deemed to be in short supply and which therefore benefit from some sort of perks in terms of sponsorship, in that there's lower fees payable for the visa, and also it means that lower salaries can be paid for those roles and they're still eligible for sponsorship. The call for evidence in terms of which jobs should be on the shortage occupation list closed recently, so on the 26th of May, and we will therefore see the outcome of that review later in the year. The MAC have already indicated and added certain jobs to the shortage occupation list. They've done some of that ahead of time. So they've added some construction jobs to the shortage occupation list, and we've also recently they've announced some additional fishing sector jobs which are going on the shortage occupation list. So there are perks, as I said, to that. So we'll look out to see what additional jobs may be added later in the year. The third change in terms of what to look out for is that the graduate visa route, lots of you will probably have individuals with this type of visa. It's a post-study work visa that allows international students to stay and work in the UK for 2 or 3 years after their studies. That was introduced in July 2021. So we're about to see the first expiry dates of those visas in around July 2023. And those graduate route visa holders, that was just a temporary visa, so they're likely to look for sponsorship from their employer, provided that they're doing a job that's skilled enough and paid enough. So if employers on the call don't have a sponsor license and you've got people with a graduate route visa working for you, it's time to think about whether it's a good idea to get the sponsor license in place, because that can take 2 or 3 months to kind of get it in place. So if you've got those expiry dates coming up, that's worth thinking about. And for employers that do already have a sponsor license, it's worth having those conversations about whether you do want to sponsor those individuals with graduate route visas and putting in place plans to do that ahead of their expiry dates. And then a final change that was just announced over the past few days really is that the UK government, having published a really high net migration figure, one of the highest we've had, 600,000 coming to the UK over the course of 2022, they've decided to put some restrictions in place in terms of international students being able to bring their family members with them under their student visas. Those changes are likely to be introduced from January next year. In terms of how that impacts employers, it might mean less international students coming to the UK if they've got a choice of places to go. but also those individuals in the past, if they could bring their family members with them during their student visa, they were then able to stay with them during their graduate route visa if they decided to stay in the UK and work. If those family members are not able to come into the UK under the period of the student visa, they won't now be able to stay for the duration of their graduate route visa. So we're anticipating more of those students might want to be sponsored under the skilled worker route from the get-go, from as soon as they finish their studies, because that's an added perk of the skilled worker route, that they can have their families with them, as well as being able to accrue service towards permanent residence rather than being in a temporary route like the graduate route. So that's just something else to look out for. And just a final word, just if you are not a lawyer or an OISC immigration advisor, do take care if you're there are lots of restrictions around advising on immigration matters, and it can be a criminal offence to do that if you're not permitted to do it. So just to take care in relation to that regulatory piece. And I think if we just move on, we're going to hopefully have some time for questions and answers. We've got a few minutes left. Erin, I don't know if there's any questions come in yet.
Yeah, there has been. So someone has asked, when the annual certificates of sponsorship allocations are renewed automatically, is there any further charge? The person that wrote this question said they've just paid £200 to get an allocation for the first time. I guess in terms of process, the automatic annual allocation renewal will be automatic for the number of certificates of sponsorship you used for the year before. So if you used 2 undefined certificates of sponsorship last year, you should get 2 automatically this year. On the basis that that's all you need, there shouldn't be any further charges until you come to assign them, in which case then you'll have the usual sponsorship fees payable. But if you need to supplement that allocation throughout the year, and some employers do need to do this if they have a surge in recruitment, or if they unexpectedly have to sponsor someone or extend someone's visa, there will still be a need to go through an application process to apply for that undefined certificate of sponsorship. And then if you're not able to wait the 18 weeks, which is a standard processing time, and lots of employers can't wait that because it is a significant period, then there is the option to use that priority service. And that is, I think, what the individual who asked the question was referencing when they said they paid £200, because that's the fee to kind of get a response quicker. And usually UKVI aim to come back to you within 5 days of your request being approved. We've had another question. Someone has asked, where an overseas national has a current British visa in their passport and the trip to the UK is within the duration of their visa, do they have to get an ETA, or will they have any problems in relation to ETA?
If they've got a visa that permits them to come to the UK, like a skilled worker visa or some other type of visa, then they don't need to go for an ETA. So the ETA scheme is principally for people who don't need visas to come to the UK. So Canadian nationals, Australians, etc., who've always been able to just get on a flight and come. But if somebody already has a visa, then they don't need to apply for an ETA. And if you want to know which category somebody falls into, whether they're a visa national and need a visa to come to the UK, or whether they're a non-visa national and therefore need an ETA to come in terms of permission to travel, that list is available online. But it's really just a change for those who've been used to having to have zero paperwork and not fill in any forms and not do anything. They're going to need to get these ETAs in place in advance. People will become used to it, but there's just an initial, I think, sort of communications thing and making people aware of that so they don't leave it to the last minute. I think there's another question here for you, Erin, about the hybrid working reporting obligations. Someone saying they weren't aware of them and they haven't been reporting these till now. Is that likely to be a sort of compliance issue?
Well, as I mentioned on the slides, the guidance prior to the 13th of April was silent on hybrid working arrangements. There was an obligation to always report the place of work for anyone that you sponsored, but it definitely wasn't completely crystal clear in relation to how hybrid working fit into that. So as the guidance has just been issued in the last month or so, it does make sense to go ahead and report as soon as possible if you haven't been doing that. So definitely check back anyone you sponsor and ensure that any kind of historic arrangements are reported and up to date. There's likely to be lots of employers in the same position because the guidance was a bit unclear, and it's always our view that it's better to report late than to not report at all. So I guess it's still a very worthwhile exercise to go through and do late reporting if you haven't done it yet.
I think that's sensible. And that's us just about out of time. So thanks everyone for joining.